Hello everyone, this is Sachin Sawant, your UK immigration lawyer. I am live after a long time. In this live, I will be providing latest UK visa updates. I have some updates throughout the live and also brief answers to your questions about under 30 seconds to a minute, answers which I can give under a minute. No salary calculations. Salary calculations are already done during paid consultations. Link for the paid consultations will be down in the description. In the past, others have benefited a lot from these lives. I will cover questions about UK visas, applications, EU settlement scheme, British citizenship, etc. etc. Everything under UK immigration. I will prioritize in this order live questions first, anyone coming live, with priority for channel members' questions in the live questions as well. Then comments on the channel, starting with the latest ones. I will start with the comments till the time I don't get any questions. I will go with the question. There are many questions on the channel as well. If you stay live throughout, I'll be giving important updates. I have my iPad over here. I have some updates which I will discuss throughout the live. Other viewers have benefited a lot from these live sessions and have saved costs, time, etc., stress on immigration advice, etc. Stay till the end of the live. Towards the end, I will be sharing some important updates as well. This is the first time I'm doing it on a desktop, so there may be some challenges, but yeah, let us see how it goes. And what else? Yeah, till the if you stay till the end, I'll be covering some specific topic about recouping costs from skilled workers, where employers are recouping some costs. A lot of changes have happened. Some in December. After that, through Immigration Lawyers Association, we did ask for several. Welcome, Babakar. Very long time, yes, very long. After a very long time, I have been live now. Okay, anyone having questions? How are you, Babakar? Okay. So if you have any questions, anyone coming live can ask the questions. I'll continue with my statements. So if you stay till the end, I will discuss some recent update on the recouping of costs, immigration costs, as the Home Office says. Uh, I will discuss that towards the end of the live. I will be live about 30 minutes now, I think 30 or 40 minutes approximately. Uh, Anyone coming live can ask their questions by the time I will. Babakar, yes, no changes to the parent visa route yet. I know your questions, so nothing has changed yet. If there is any problem with the sound, etc., please let me know. Okay. So I can see, I think 8 people are live. Parent visas are still taking about up to 12 months. Yes, they are going 10 to 12 months. There is no standard processing time. Basically, Home Office says no processing time. But we are seeing they are currently last month about 11th month mark. So between 10 and 12 months. That's what approximately it is. Okay. Okay, good. I can share my screen also in this. Very good. Should I share my screen? Let us see. Anyone having any questions can ask me. By the time I'm just trying to go into the channel and see any questions over there. Questions are over here. Okay. Okay, one live question. A child has stayed in the UK on ICT dependent for 4 years plus skilled worker dependent. Okay, for 3 years, 4 plus 3. Now just switch to private life just before turning 18. Okay. Now after 1 year, can they be eligible for ILR? How are you calculating that 1 year? 4 plus 3, 7 plus something. What is the 1 year that you are referring to? Usually the child will have to complete 4 plus 3, 7, but that's not on private life route. So you have to complete 5 years on the private life route. The child will have to complete at least 5 years on the private life route. Only after that they can apply on the private life route ILR. But if it is 7 plus 5, 12, the child may be eligible at the 10-year point if on the 10-year long residence they are meeting all the requirements. So either the 10-year long residence point or the 12 years. So it is 7 plus 5, 5 years on the private life route. Only then the child will qualify. I'm not sure what the 1 year mark that you are referring to. Okay, question on the channel. Let us show some screen community tab. Good. Okay, I can also share my screen. Very good. So all these changes from YouTube. Very good. So what this is the question I have. How can I get the share code with ARC card? Please reply. With the ARC card. ARC card is the asylum. It's a card that shows that asylum registration card that you have applied for asylum. So your employer has to do a right to work check through the ECS, employer checking service. You don't get a share code. You have to go to the employer, give them all your details, and then they will do a right to work check through the employer checking service, and home office will give a positive verification, and then you can start working. That's how it is done. Okay, what happens? Like you're not well. Yes, I'm not very well. Last 2 weeks I have been having, yeah, today only morning, I think last night I finished my antibiotics. Yeah, I do have a little bit of cough as well. But yeah, I haven't been live for a while, so just thought of using my time. Thank you for asking, anyways. If I'm extending for HUD, if I'm extending my tier 2 visa and pick up a job from ISL 212, okay, specific graphic designer, what salary would I need? First course was October. I'm very sorry, I cannot do any salary calculations on the lives, but I will try and answer to a certain extent whatever I can. Uh, Although because it's pure immigration advice and all our consultations are recorded, everything is properly documented. So that's the reason immigration advice need to be properly documented. That is for our own audit purposes. So I will answer some part of it definitely. What salary I would need? 2142, and you got your first in October 24. So you are not. Transitional provisions only apply before 4th of April. Let me see all my notes over here. Okay, so this is transitional. Transitional provisions will not apply to you. You got it in October, so you are with the new one. Okay, let me anyways try to do it if I can. I'll just try to do a sample for you. I know I will not do salary calculations. That's what I said. Let me try if I can. You will be subject to the 41,700 minimum if you are not getting any of those discounts of new entrant. So there is no transitional provisions since you joined in October. Transitional provisions only apply if you joined before April 4th, 2024. So I don't know what the salaries are now, but then yeah, your base salary would be 41,700. Let me try to find out if I can. Try to see 2142. Just a minute. Sorry, I'm trying to find something on the screen. 1 minute. Just 1 minute. I'm doing some customizing. Save. Okay. Yes. Fahad, if there are no more questions, I will try to find it. Let me answer Abdul's question. My course was issued before 3rd April, so you're not transitional, but visa was issued in May. And new rules apply or old rules apply. Don't worry about the visa issue date. It's the date of assignment of the course. That's how the rules apply. We've got this clarification from Home Office case working team, even the case managers and directors. we've asked these specific questions. So anytime the changes happened, whether they happened April 2024 or July 22nd this year, for you specifically, let me be specific. Yeah. So you are in the transitional provisions. The cost assignment date does apply. Okay, for Fahad, let me try to find out if I can do one. What is the number? 2142. 2142. Okay. KBI going rates 2142. Graphic designers 2142. So you are 30. 33,400 is the, you will have the higher rate, 33,400. Or yeah, it would be, so it's either 33,400 or 41,700. So it is 41,700. That's what you should be paid for the 37.5 hour weeks, provided there are no discounts of anything. Okay. So this answer is for Fahad Beg, 2142 graphic designer. You have to be paid 41,700. My understanding is no discounting is done, no new entrant or anything. Standard rate would be 41,700. So, Rajin, my skilled worker visa application was approved after 1 year of application date. Now, does this 1 year of awaiting period count towards ILR 5 year? Was this an extension or was this the first application? If it was the first application as a skilled worker you applied, then no, it does not count. If it was an extension and Home Office took all the time to extend, which means you had skilled worker, you applied and waited, and again you got skilled worker, then yes, it will count towards your ILR. When I will extend my visa on skilled worker visa, my company need to increase my salary. So yes, increase has to happen definitely, but it will be, so the way the increase works for you is when you apply for the permission, you the base may be 29,000, I think 29,000 or 25,600, but the base for you will be 31,300, 31,300 or the going rate, whichever is higher. That's how the formula will be for you. So this answer is for Abdul Rahman, 31,300 or the going rate for that job code, whichever is higher. Thank you, Fahad. Thank you. Okay. Let us do something. Okay, so there is a paid member, Dilatronic. He has asked, hello boss, as paid member, okay. Is it possible to apply for a skilled worker visa with 36.5 hour working job contract? Yes, it is possible. But then what else? What are you asking? On a 6 month contract? Or would the application be rejected if I submit it for 1 year given the contract is only, I don't know what contract you're referring to. Is it the employment contract or the client contract or whatever that is? It basically does not matter. The employer who is giving you the contract should have. So if they're giving you an employment contract of 6 months, they cannot sponsor you for more than 6 months. It doesn't work like that. So your employment contract has to match the period of work start date and work end date on the costs. So if they're giving you a 6 month contract, they can only sponsor you for a 6 month work start date and work end date on the costs. Now, yeah, so that is about the cost aspect. If it's a 6 month employment contract, only 6 month cost. That's how it is. Or they have to give the 1 year employment contract to you. And 36.5 hour work week, yes, they can give it, but then proportionately you will always be subject to that 41,700, assuming you don't have any discounting. 41,700 would be there. If you have discounting, then whatever is the discounting rate, let's say you joined the route before April 2024, so your base is 31,300, so it would be 31,300 or the going rate, whichever is higher. So the going rate can be calculated as per 36.5 hours, but that 31,300 base will remain. That cannot move as per the hours. So that's how it will have to be calculated. Yes, for any salary calculations, please book a paid consultation. I cannot do it. I'm just trying to help out whatever I can over here. Okay, thanks, Bhuvakar. I sir, my child will join nursery next month. The letter from the nursery will confirm drops and picks is good enough for parental. Yes, that should be good enough. I have done many cases. I have represented. I have explained many times. Caseworkers asked for something. Okay, I don't want to comment on that. Whatever GP letter, healthcare visitor letter. But then yes, I have myself. We have been able to explain with even nursery letter, sometimes school letter. So nursery letter confirming that this child is registered with us, has been in our nursery since whatever period, 1 month or so. Babakar is registered with us as as one of the parents to pick up and drop off the child. He regularly picks up the child and drops off. Whatever activities you do, they need to mention that. And the more they mention, the better it is for your case. Okay, that's how it is. So, Munawar Pasha, can you please explain 10 years long residence changes with any examples? 10 years long residence changes, not recent changes, but there were several clarifications. I think last April the changes happened. After that, the guidance and some clarifications came. One very important one that I do remember is okay, so if I'm trying to apply for a 10-year long residence ILR right now, as of today, I should be on that road. Let's say I'm on skilled worker today and I'm applying for 10-year long residence. This is my latest permission. I should be on this route for minimum 12 months before making the 10-year long residence application. So minimum. So for example, let's say I just switched from skilled worker to a spouse visa next month. Okay. And I'm trying to apply. I'm only 10 days in the spouse visa, new visa category. Then I cannot apply for the 10-year long residence because on the latest immigration category, I'm only for 10 days. I have to wait till I complete at least 1 year on the spouse visa and only then I can apply for the 10-year long residence. That's the important one. That was the major one. Other one, the 548 days absences and 184, 548 has gone out. Okay, so basically the total absences limit has almost gone off. So the way the rules work is when the changes happen, I don't have the exact dates, but I think some April, maybe last April or so. Till that point, the 548 day rules apply. So if you have a 10-year block, 1 year is after the changes happen and 9 years is before the changes happen. If in the 9 years before the changes under the old rules you already accumulated that 548, you were 549, whatever, 549, I think that's the number, then you have broken the continuity of residence. You may have to go on forward and then make bring your date forward, so move your 10 years block forward. But if in that period you have not broken the 548-day rule of the total 10 years, more than 548 days absence, then it doesn't matter, that rule is gone for you. So if you're applying for indefinitely to remain on long residence today, then 548 days doesn't operate. Only the 184 days in any 12-month cycle does apply, which is the same as it applies to a skilled worker ILR or any other ILR for that matter. So those are the two main that I remember. It's long back since the changes happened. So what was the main one? 548 taken off, and this one. Those are the only two main that have changed, to the best of my recollection. If you remember anything, just ask me. I will clarify. Okay, so Abdul Rahman. If I have a residence permit in the UK and I also apply it in the USA, will the UK and the USA share details with each other if the USA issues me a residence card when we cancel? No, the latter is not true. USA issues a residence card, UK will not cancel. But yes, the details are shared. Criminal details, immigration overstays, and all of those things are shared. That's what I'm aware of. Okay. Okay. So I answered this one. Let's mark this one. What if your visa? Okay, next question. What is this question on? Okay, let us see. What if your visa has 3 months shortage for the 5 years, but in your course it stated 5 years, but when visa came there was 3 months short? Yeah, if that has happened, usually you should write back to the case working team and get it sorted. If they have given a short 3 months, usually it doesn't happen. It's a rare occurrence. I've seen that, but then yeah, they should sort it out. But then if you are short, just it doesn't help you anyways. If it's a mistake, it should be rectified. That's what I would say. Because of course was issued for 5 years, they should give you a 5 year visa. Very simple. Because you paid for 5 years visa fees, 5 years IHS, it should be rectified. Whoever your employer, your lawyer, who has, they have to follow up and get it sorted. If for any reason they have done it correctly and yes, you got 3 year, 3 months short, you may have to apply for an extension at the end. And then as soon as you complete your 5 year block, or when you come within the 28 days of the 5 years, 4 years and 11 months and 2 days, let's say, at that point you can vary that extension application and save your extension fees and file for indefinite leave to remain. So that is also possible. Do that only through immigration lawyers. Yeah. Okay. Okay. No more live questions till the time. I will take this one. Okay. About time comments. Okay. Okay. I hope you are doing well. Yes, I'm well. I have question regarding processing times for skilled worker visa and the standard service nowadays. Submitted my application for skilled worker 24th of August. Still awaiting output. That's almost 4 weeks when I expect. Skilled worker processing time, may go up to 8 weeks if you have applied inside the UK. Outside the UK, you usually get it in 3 weeks. Yes, 15 working days. About 3 weeks or so, you should get it. There are no delays. We have confirmed this last week. We got an update from Home Office, so there is no delay on either end, either inside UK skilled workers or outside UK skilled workers. There is no delay. They are on time. Yeah. So what else? JJ, this will be helpful. Thank you. Could you please kindly answer this question? Can a restaurant manager of code medium skilled who is hold a skilled worker visa from 2022 hold roles to a different employer switch for the same job now? Okay, let me think through. So you are on a medium scale because you are under 6. Yes, you should be able to switch. Let me think what should be a salary threshold. Yes, you can switch to another employer. About the salary threshold, sorry, I will not get into the salaries. You have to book a paid consultation. Yeah, that's where I do it properly, taking further information and everything. You can switch to another employer. That's what I can say. Please, can I know the processing time for? But one thing I can help you out. The you will be still under the transitional provisions. So the base minimum of when you applied in 22, the base was 25,600. I think so, 25,600. Now the base minimum when you switch will be 31,300 or the going rate of that particular stock code. So that much I can help you. 31,300 will be your base because you will come at the transitional arrangements. Anyone coming live can ask your questions. Okay, let me give some updates as I promised. I have here something. Okay, one important one. About long residence, anyways, who was asking? Somebody was asking. Oh yeah, Munawar. Yeah. So long residence currently, if anyone is applying, I'm not sure if you're eligible now. So currently, long residence super priority service. Everyone tries for it. There is a long queue, so everyone tries it. No one gets it. That's where it ends up. Even lawyers have a hard time. Home office. So we know from home office that the super priority slots are available. Yes, we have got it many times. We also get it now, but it is hard to find because every day they release limited slots, and once they are filled, that's it. Nothing doing. So whoever, it's first come first. So one of the solutions for that we do. So this is one of the updates we know. I know from home office we've got the slots are capped. It's not unlimited. Everyone who's filing for long residence ILR will not get super priority service. Everyone wants it. The demand for long residence ILR super priority is very very high because no one wants to wait for 6 months with all the uncertainty, etc. So one of the workarounds that we do, if you are faced with or anyone is faced, is this is one thing that can be done is you file a standard application, parallelly create another application. Usually always do this through lawyers. Okay, we have our covering letters and all, but this is what we do. You file a standard application, put it in the queue, at the same time prepare another application and keep looking for the priority slot. As soon as you get it, you submit it, and that new submission will be in the covering letter. We explain that this is a variation of the previous application. So the new one will be decided on the super priority 24 hours timelines. And as soon as that decision is made, they will also treat the previous one as void or withdrawn. and refund the previous application fees. But important thing over here is you need to have two application fees in hand, whether a credit card, line of credit, whatever that is. You need to make the standard fees and then also the super priority and the visa fees together, ILR fees together, and the first one will be refunded. So you don't lose anything on the cost, but this is a workaround that we have done a lot of times. There is one workaround I'm just sharing, and what else? Okay, so another update was this one. Okay, another important one. Yeah, this was a clarification. The changes, as I said, I will discuss this. The recoupment of cost. This is a very sensitive area. Home Office has been having issues with it for a long time. Last year, December 2024, the rules changed, stating clearly that employers cannot recoup any of the sponsor licensing costs. License fees, 576 for small employers. I'm just giving examples over here. The certificate of sponsorship fees, 535, I think so. And the immigration skills charge, which is 364 per year of visa for a small employer. These three cannot be recouped. Very, very important. However, salary sacrifice, however, if the employer recovers these costs and home office becomes aware of this, either in a physical audit or in a virtual audit, or when they ask for additional information when they apply for costs, nowadays it is very common. I've made another video you can watch. Additional information for usually for D costs, U costs is very, very common. 80% of employers are getting this, that additional information. Through that additional information, if they do find out in the bank statement, or however they find it out that payments have been made, or however they have recouped it, the sponsor license will be will be revoked. 101% it will be. Now we wanted clarification on other aspects of the, where we got some further clarification from Home Office, and on 9th of April, Home Office clearly said that immigration costs also cannot be recouped. That was, and we clarified, we asked them questions. Immigration cost doesn't include main applicants and dependents, visa and IHS cost. They said yes, if they are being recovered. So this is immigration cost number one. Uh, if they are being recovered, maybe throughout every time from salary, then proportionately they will be reducing the minimum salary level. In my example, I will take it as, let's say your salary quoted on the cost is 40,000. Okay, or 42,000. Let me take 41,700. 42,000 is your salary, and a total cost of 18,000 is the employer is going to recover, and it's a 3-year cost. So the home office, when they calculate the salaries, the way they will do it is they will write down your 42,000 as salary, and they will reduce. So it is 18,000 divided by 3. 3 years cost. Every year they are calculating it this way. You will be recovered, the employer will be recovering 6,000 from you. So 42 minus 6, and it will go to 36,000, and you will not meet the salary requirement, and the application will be refused. Very, very important. I have seen refusals like that. Okay, so that recoupment of cost, and anywhere home office comes aware of it, firstly, home office employer should notify any recoupment. They should write in the sponsor notes if it's a live cost. If they've just issued, they can put the notes and say, this is what is going to be recovered over whatever period. If it's already assigned, by reporting separately to the sponsor management system. Home office is very strict on this, and they have clarified these all things should be reported as a salary reduction, whatever you are doing. And after the reduction, the minimum salary requirement has to be met. So this is a critical one. We clarified whether even dependents costs will be treated as immigration costs, and Home Office has said yes, they are treated as immigration costs. So I think the only way is to just go independently and take a loan from the bank. If that is of a question, don't take any help from the employer. So this was the main question that we were getting at, asking questions on, can the employer help with the costs and all. And finally they are coming back saying no, no to most of them. It will always be the total length of sponsorship. Yeah, at the end, these should be reported. All these recovery should be reported through in the same way as any reductions in salary. So through the cost, the sponsor management system, data domain applicant applied. Yeah. Okay, I'm just looking at all the answers over here. Yes. So this is an important update. I just wanted to put it through. Okay. So Ruthie James, if not getting enough hours because of job shortages, is visa extension possible? Not getting enough hours. That is always a challenge. It's more an employer's duty. It's more an employer's compliance. It doesn't come on you. If the employer is extending, I've not seen issues with that. You cannot extend because it is always an employer gives you a cost, either a new employer or the same employer, and the employer confirms everything on the certificate of sponsorship. So they are responsible to pay whatever salaries. They may lose the license or whatever that is, but yeah, it is not against the employee per se. So you can extend to get the cost. Honorable Pasha, I would request you to consider the option for students to book cancellations for short period and feasible amount so that we can clear some doubts regarding short periods. Yes, I have thought on that, but yeah, I may come up with something. Yeah, I know other lawyers are doing some 10-minute consultations, but I'm not sure how much. Yes, 10 minutes I can back up a lot of things. Yeah, maybe I will publish something in the next live or something. I have to create a link for a 10-minute consultation or something. But standard one is 30 minutes. Yeah. So in 10 minutes, yeah, I answer a lot of questions. I know. I will try to work on that one. XIT, thank you for the suggestion. Is SOC 1223 eligible for existing skilled worker visa? I am on skilled worker visa since 2021 and continue since then. 1223 skilled worker visa. When I apply for allocation, the 1223 not eligible. Yeah, sorry. It's a very specific job specific question. There may be alternative job codes or something will be definitely there because many stocks have split into several. The numbers have changed. You should speak to an immigration lawyer. There will be a solution. It's not the end of the world. Either book a consultation with me or go to any other lawyer, and we have to do a proper analysis of what has happened to that stock code. Where has it gone in the system? There will be an answer definitely. There is the Cascade tool. There is a way to find it out. Close job code, close a similar one, but there is a way. Mavis said not eligible, so they did not allocate any on its medium scale. When I checked, also they said it's yeah, but anyone who is already on that job code can extend it. So there are ways. If you are already on that job code, yes, if it is not sponsorable as of now, that is perfectly fine. Home office is right in saying that. But then if someone is already there and they're extending, then definitely there is a way out. So that's what I can summarily answer that. But then yeah, speak to an immigration lawyer and they should be able to help you. Everyone, all those medium skill job, they don't have to leave the UK and go back home if they are already under the rules before 22nd of July 2025. They will have an extension option. It's just finding the right code, matching the job details with the job description, etc., and finding the closest one and the exact salary. That is where you have to get it. Okay. And I will answer some questions over here. Processing time for EUS's family permit, maybe 6 months. That's to the best of my knowledge. About 6 months it is taking, and slightly more for some cases. Thank you, Manoba. Thank you. Yeah. Okay, what else? Okay, next question here. House of Wisdom. Everyone can see the screen. Yes. My partner is an EU citizen with indefinite. I did apply under the USS because I had no evidence of a relationship existence before December. So I paid for visa fees and applied for visa settlement. Am I still considered EU member dependent? You won't be able to apply anything under the EU settlement scheme because you didn't have evidence. It was the first instance you had. You should have applied at that point. But if you don't have evidence, you would not get it at that time, and you would not get anything now also because you don't meet the rules for EU settlement scheme. So yeah, that video doesn't help you basically. That is only for people who have some status under the scheme. Chef visa lag rahe hai. So I think he's asking for chef visas. Yes, I think so. Yes, if you are eligible, it's a genuine job and everything to be possible. Okay, I'm a skilled worker visa, and me and my dependent visas are valid till 27. If I change employer, do I have to get fresh visa for my dependents? They keep using the original dependent. This is a very common question. So if you are changing employers or extending or whatever you're doing, changing employers usually, your dependents don't have to file at the same time. They are still on PBS dependents. So they can continue till the time their visa expires and then extend or file IR, whatever they are eligible for. So that is the let's mark it. Okay, so here it is. Entered in UK on spouse visa August 25. Baby was 16, separated, recorded message of why update who had updated some time. It just said once you get court permission, let us know. Court permission, okay, to have the child's custody or joint custody. Granted FLRFP under 10-year rules. So far, I have completed 10 years locally in the UK. What is the meaning of locally? Lifetime in the UK. Yes, time spent on spouse visa can be counted towards 10-year long residence, ILR. So you got spouse visa. Provided you had continuous visas, you had at least Section 3C leave. So you had a spouse visa, then some Section 3C leave, whatever your applications were pending, and then 10-year root permission as the for the parent. Yes, all this can be combined into a long residence application if you are completing granted FLRF in 10 years. Okay. Yeah, if you, yeah, I think you mean 10 years totally you were completed in the UK. If these are the only visa categories, make sure you're not on any of the other visa categories like a visitor visa or anything like that, which cannot be counted towards a 10-year route. So that is it. Yes, you can accumulate and you can apply. You don't have to wait for the 10-year parent route to be completed. If you already hit the 10-year long residence mark on different combination of visas, spouse visa and parent visa, let's say, you can apply. Okay, so this was up to date because I applied for 10-year private life super priority in March and listen to this. Yes, that may be an older video that you're looking at. That's correct. 100 because I applied 10-year private life super in March. Yes, that's good. Thank you for updating me as well. 10-year private life. Yes, it is possible if you have permission. Okay. And there are no more questions. Let me take Ruti's last question. Does an infant need to be on a dependent visa? What is the age I'm extending? But not sure if they will need to be on a visa. If the child is born in the UK, then the child does not need a visa unless they are traveling outside. A child born in the UK cannot be an overstayer. They are legal in the UK, whether or not they have any visa. So that's perfectly fine. I'm assuming your child is born in the UK. I need to be a dependent visa. You don't have to apply for the dependent visa. It's only required when you go outside the UK and the child is traveling in, you may have to apply, or you can apply and then plan the travel. If there is no traveling planned, the child doesn't need to have a visa. Yeah, you can wait till the time you get your indefinite leave to remain, and after that, if the child is born in the UK, the child can directly apply to register as a British citizen. They don't need any visa, no dependent visa, no ILR. You can save all the money, but the problem is the child cannot travel till that point. Anytime that they travel outside, they will need a visa to come in. So then you have to apply for the dependent visa. But yeah, if the child is just living in the UK, not traveling outside the UK, they are fine. They don't need any visa. A child born in the UK cannot be illegal. This is another common question. I people assume this that they may be. I was speaking to last one client last week also. They assume that children born in the UK they don't have a visa. They are illegal. It's not that they are legal. They are born in the UK. They didn't come anyway. So yeah, you can avoid filing the child's application till whatever time the child is not traveling outside the UK. Okay. So yes, this was a short live, about 40 minutes in. No more live questions. I'll try and do lives maybe after a long time. I've done a live since April now. So thank you for joining. Anyone joined, yeah, subscribe and like this live. If you need any advice on your own matters, do book a consultation. Link will be in the description. Thank you very much. I'll end this live now.